Good morning and welcome to this morning's session of the Kansas Court of Appeals meeting by Zoom. We appreciate Council's willingness to do that today. I'm Catherine Gardner, and sitting with me is Judge Stephen Hill and Judge Leslie Isherwood. So the case we are ready to hear is 124487 in the matter of the marriage of Emmanuel Daon, appellee, and Maria K. Stewart, appellant. May I have your appearances, please, Counsel?
Your Honor, may it please the court, Maria K. Stewart appears through Joseph Booth, and I wish to reserve 5 minutes for rebuttal.
Thank you. You may have that.
May it please the court, Preston Drobeck on behalf of the appellee, Emmanuel Daon.
And Mr. Drobeck, it's a little difficult to hear you. If you could speak up, then that would be appreciated.
I'll do that, Your Honor.
Okay, thank you. Mr. Booth, you may proceed.
Thank you, Your Honor. This case comes before the court really on a focused issue of the 224 words in the 529 language set out in the marital separation agreement. And as the court is aware, this court has de novo powers to review the content of contracts. So I won't focus as much on what I feel the court erred in deciding below, but rather focus on these contract terms and describe my client's position. The first 71 words really are the meat of it. Any 529 or uniform gift to minors accounts existing for the benefit of the minor children are to be held in constructive trust for the children. And I'll pause there. The parties to the agreement contemplated the existence of accounts. There were 2 accounts, one for each child. The accounts were split, as a matter of fact, by mother having one account that was under her name as a 529 account, father having the account for the elder child, which spurred the litigation in this situation. And it too was a 529 account under his name. The language here transferred back 10 years ago, the ownership of the account from the record owner of the 529 account to this constructive trust. At that juncture, if not earlier under the tax law, these Uniform Gift to Minors Act accounts belonged to each subject beneficiary child, but they were minors. The language goes on to say, with mother and father distributing the funds as they agree to be in the children's best interest until such time as the funds belong to the children. This language is very clear in the sense that it holds the trusteeship under the constructive trust for a specific period of time. And that is between the creation of the trust, which is in the separation agreement itself, and then finally until such time as they belong to the children. And that means that they will be transferred to the children upon majority, which is where the i.e. give uniform gift to minors accounts or reaching majority under the terms of the original conveyance.
Mr. Booth, may I interrupt you to ask
Please.
About that last phrase?
Yes.
What was the original conveyance that language is referring to?
The original conveyances in this case, as a matter of fact, were the creations of the 529 account. And as you know, a 529 account does not in and of itself define or deal with the majority of a beneficiary or an owner. But without a specific plan document that dedicates that, it is our argument that 38101 applies, and it's simply by the age of the child reaching majority. So whatever, with the Uniform Gift to Minors Act account, they could have set a number of possibilities for the age of majority under the terms of that conveyance. They didn't choose to do that either at the time that they created the original accounts, or when they also, in theory, could have transferred those to Uniform Gift to Minors Act accounts.
Mr. Booth, may I ask you a question?
Absolutely.
At the time of the creation of this, could the parties have said until each child attains the age of 21 or 25 or 30? Did they have the ability to do that? And could they have done that legally?
Yes, yes, and yes. And it is frequently done in separation agreements where the parties set aside college savings and have the intention of at some point releasing ownership to the beneficiary child. Some of these marital separation agreements don't contemplate that the child will ever actually have full ownership. And some specifically say that the child is not a full third-party beneficiary. But in this case, they did the exact opposite of what those exceptions I just noted, and they contemplated holding the account as co-trustees over the accounts until such time as they reach majority. So it's as would be argued later when we talked about conditions in the process of the briefs, it's a condition subsequent. The contract's formed, it's in full function, and then it has a termination date for the role of these constructive trustees.
So in the absence of any specific agreement like that, we are to infer that the age of majority, the legal age of majority, is when the agreement ends. Is that correct?
Yes. Basically, a way to say that would be the contract requires the transfer of these funds upon the age of majority, and you got to go find it somewhere. And it could have been, as you noted, in the separation agreement by picking a particular objective date, or it could be noted in the original conveyance documents. And if you don't have it either there, those are all exceptions to the general public policy of what the age of majority is in the state of Kansas, and that's 18. Does that answer your question?
Yes, thank you.
The court below took additional umbrage with the second paragraph that deals with the interplay between the co-trustees and what would happen if one or the other acted independently to the tax detriment of the other. And I believe that's important language. It's constructive to the entire agreement, but that whole paragraph becomes moot for the elder child's trust once he's reached the age of majority. It doesn't define or further clarify the intentions of the use of this trust. These are often called college savings trusts, and as a matter of fact, the whole campaign is over college savings, but that phrase itself is a misnomer. College savings accounts have long migrated to be able to be educational savings accounts, and they're able to be used as contemplated in this language for any time during the time of the existence of the account for the subject beneficiary. And it's in the terms of this trust, the parties were free to distribute those funds in any way that they agreed from 2012 until the age of majority. Those are all examples of the way in which this trust operated and what the trustees' jobs were. In other words, there wasn't a mootness or a contradiction between the idea that these are college savings accounts, and most students who matriculate in college are past the age of 18. That's just a law of averages, but otherwise the trustees were on duty and had duties to perform during that time. It's also quite clear that this is easily fitting within the other law, and that other law being the federal and state interplay of how to manage and transfer interest and ownership. This is not, the plan document may state that mom or dad, and in the case of the instant litigation, it would have been dad, had some ownership right and some discretion over which they could limit distribution or defer these funds elsewhere. And in the lower court, there was a concern over the terrible tax risks and the consequences that an 18-year-old might rack upon their father if they misuse that account. That's simply not so. KSA 75-646 makes it clear, and the federal law leaves it to the state law, that you can transfer ownership from one family member to another, in this case from father to son. So you have the transfer of ownership in the 2012 separation agreement to the constructive trust as a matter of the subsequent agreement. But under the terms of the 529 account, you also have the ability to transfer that ownership upon majority. All the child has to do is open their own 529 account. It moves over. It's a little bit like what we're used to seeing in a quadro, and you can move these proceeds into the control of the child. The lower court was concerned about the wisdom of whether or not one would give an 18-year-old child the keys to the kingdom, so to speak. There are a number of answers to that, but the best one is they did. That was the decision they made in 2012, and that's what this language says. And there are many parents who would give broad discretion to their college child as a way of furthering the experience of and the teaching of lessons on how to handle one's own responsibilities, and would do that. What would be unusual in this instance is that they seemingly predicted that they knew that these children, who were little whippersnappers back then, 12 years later, in the case of the elder child, would be worthy of that trust. But the way to become worthy of the way children become worthy of parents' trust is that the parents trust them. And this couple made the decision that they were going to transfer these assets upon majority. And any further questions?
Okay, well, thank you. Mr. Drobick, you may proceed.
Thank you, Your Honor. May it please the court. As Mr. Booth pointed out, this case really boils down to contractual interpretation. The only thing this court needs to decide is what those two paragraphs from the parties' settlement agreement titled 529 education accounts, what that means. This isn't a case where Mr. Booth and I are arguing over the law or which principles to apply. We agree there's a de novo standard of review here because the court is interpreting a contract. We agree that the divorce agreement should be treated the same as any other contract, and that the court doesn't have jurisdiction to modify it, but only to interpret it. The court should liberally construe it to carry out the intentions of the parties. Those intentions should be determined from the four corners of the document itself, as long as the document is not ambiguous. And only if the court finds it to be ambiguous would the court then employ the rules of construction and consider outside evidence of intent. It's my position that a plain reading of the provision supports the trial court's interpretation that the parties did not agree that there would be an automatic transfer of the children's 529 funds to the child at the age of 18. One of the contractual principles cited in the briefs comes from the Hill case and is also quoted in the Drummond case. And that's that the court cannot make an agreement the parties did not make for themselves. And I believe that's exactly what Mother's asking the court to do, is to add to this agreement a provision that would automatically transfer these accounts to the child at age 18. But that's simply not there in the language.
Mr. Drobick, may I ask you a question, please?
Of course.
Since you two are both looking at the same language, it seems to be a very narrow portion of this document that controls, and we're interpreting it. You interpret it totally differently than Mr. Booth. Does that mean it's ambiguous? Your
Honor, I don't believe so. I think it's definitely on the line. The language that's really at issue is that parenthetical that says, i.e. Uniform Gifts to Minors Act accounts or reaching majority under the terms of the original conveyance. And we agree this isn't a UGMA or a UTMA account where the funds would automatically transfer to the child at 18 or 21. So we're basically just dealing with that one clause that says, or reaching majority under the terms of the original conveyance. I don't think that's so ambiguous as to require the court to go outside of the document. But I would admit that language it's awkward and unwieldy. It's not worded great, but I think it's quite a leap to take the interpretation that Mother is taking on that.
Counsel, I asked Mr. Booth this question, could the parties have set a different date, saying that the asset would transfer at the age of 21 or 25 or 30? Could the parties have done that?
Absolutely, Your Honor. And I believe that's what they would have done had that been their intent.
But unfortunately, they didn't say anything like that. So we're left to decide, well, when does this end? And what did the trial court decide? When does this ever end? Does this go on until what? The trust gets tired of doing this? Somebody turns 50? Or when do you turn it over?
Well, that may be the case, Your Honor, because as you correctly pointed out, the agreement does not state when the funds transfer to the child. The trust ends, as it says, until such time as the funds belong to the children. So that until signals we've got this potential eventuality. So clearly the parties contemplated that at some point the funds would belong to the children, or they wouldn't have put that in there. But they don't state when that occurs. They don't state that it ever has to occur. I called this a condition precedent in my brief, and my opposing counsel corrected me and called it a condition subsequent. And frankly, I think he's correct. I should have known better than to get into grammar in my brief. But the point is that this until signals just a potential eventuality. The trust ends at whatever point the children own the funds, but the agreement does not state any point when that must occur.
Well, so then we are to enforce an agreement that never ends.
That may be the case, Your Honor. That's what the parties contracted to.
Is that a reasonable result? Do you think that's what the parties said, that we will keep these funds forever?
No, I don't, Your Honor. I mean, I definitely believe that the parties intended that at some point those funds would belong to the children. But I think that their agreement left that to their own discretion. Just like whether or not they make any distributions, it says that's as they agree to be in the children's best interest. I think when they drafted this agreement that they intended at some point those funds would be turned over to the children. What the agreement clearly doesn't state, though, is that that happens at age 18. And that's mother's argument, is that this happens automatically because of this phrase, or reaching majority under the terms of the original conveyance.
And is it your argument that it's an unreasonable result?
Can you rephrase that question, Your Honor?
Is it your argument that it is unreasonable to approve the argument made by mother in this case, that it automatically ends at 18?
Yes, Your Honor. I think, I don't think that's what the agreement says. So I don't think the court has the jurisdiction to read that requirement into the agreement.
Okay.
But B, getting more to your question, I do not think that's a reasonable interpretation. I think the agreement by its own terms, when you look at it as a whole, as opposed to this isolated clause, the agreement was designed with the parties providing for their children's college education and making distributions as the children were in college. And that's something that the trial court noted. And it's also something mother addressed in her brief. And mother correctly pointed out that 529 plans are not only restricted to college expenses. They can be used for private school tuition. They could be used for other college related expenses that might be incurred prior to the child turning 18.
So if somebody wanted to go to, one of the children wanted to go to trade school or receive some advanced training and becoming a pilot or something like that, could the funds be used for that?
Yes, Your Honor, I believe so. But the parties referred to this plan in two separate places in this provision as a 529 college savings plan. Mother calls that a misnomer, but regardless of what the plan's called in the law, this is the language the parties used in their agreement. So I think that's further evidence of intent from the agreement itself, that the parties intended that these funds would be used for college.
So we shouldn't be bothered with labels. We should look to the language of the agreement.
Correct, Your Honor.
Let me ask then, do you agree with Mr. Booth that the language of the agreement, when it refers to the original conveyance, is talking about the creation of the 529 account?
I do, Your Honor. It's obviously much more generic than that. It doesn't say a 529 plan. It says the original conveyance. But in the case of the account that we're talking about, I agree. I think what that clause is saying is, I think it's a bit of a catch-all is what I think. It says, i.e. Uniform Gifts to Minors Act account, which we know in those cases, there's an automatic transfer to the child at 18 or 21. And then that remaining clause, I would interpret as basically saying, or if the funds transfer to the child under some other terms in the original conveyance. So in this case, we're talking about a 529 plan. So if there were some other terms in the 529 plan conveyance that would transfer the funds to the child, then of course, at that point, the constructive trust would end. But mothers admitted that there is no automatic transfer in a 529 plan. There's no definition of majority in a 529 plan. And I think it's quite a leap to say that, well, because there's a general statute that says a child becomes an adult at the age of 18 in Kansas, that from that, we're going to extrapolate that the parties agree that the funds must be transferred to the child at age 18. I think that's a bit of a stretch. Mother cited in her brief the Einsel case, which says the court should look at all pertinent provisions and not an isolated one. And I think she's kind of doing the opposite. She's focusing on this one phrase and trying to extrapolate from that this entire requirement that's not there. Whereas if you view the provision as a whole, you see this was clearly designed for the parties to save for their children's college. The agreement talks about them making distributions as they agree to be in the children's best interest. It's clear that their intent was they would be making distributions as the children are attending college, which in this case is after the children turn 18.
So let me ask a related question. When the language says we will distribute the funds as we agree are in the child's best interest until such time as the funds belong to the children, does that phrase, when the funds belong to the children, relate to a distribution this year and a distribution next year and a distribution the following year, rather than to when the child owns the account at one given time?
I believe it's the second, Your Honor. I know the trial court made some comments about the funds being essentially owned by the children at the time each distribution was made. I don't think that's a particularly reasonable interpretation. I do think that until is referring to at such time as the funds are actually owned by the children as opposed to the trust. But again, I don't think the contract says that automatically happens at age 18. Mm-hmm. Looking at that best interest phrase also then brings me to mother's second point in her appeal, which is that the trial court erred in essentially not just ordering father to pay the college expenses, but imposing his own criteria to determine the children's best interest. This issue is much easier to resolve based on the clear language of the agreement, because that phrase comes directly from the agreement. It says the parties distribute the funds as they agree to be in the children's best interests. So when mother asks the court to remove that best interest factor and just order father to pay the college expenses regardless, that's really asking the court to modify the agreement, which we've all agreed the court legally doesn't have the authority to do.
Mr. Drobeck, may I ask you a question, please? In line with what you're discussing at this point as far as the children's best interests, I'm struggling to conclude how your client's conduct in forcing a relationship with Alex is necessarily a joint agreement, first of all, between the parties, and then secondarily, how that's in the children's best interest. To me, this seems to be a unilateral decision on the part of your client to force something that is in his best interest, not the children's best interest. So if you could address both pieces of that, please.
Certainly, Honor. The criteria that Mr. Daon imposed was he wanted to meet with his child, I think utilizing a counselor. He wanted to visit the school. I didn't interpret the evidence as he was insisting necessarily on a relationship with his child, but he did want to be involved in the decision. So I do think it's reasonable for a parent to say, before we spend thousands of dollars that we've set aside for your college education, let's make sure you're making the right decision. Let's make sure you've visited the school and know this is where you want to go. Let's have a conversation about what your plans are. I don't particularly know that, because I don't believe at trial they got into the details of exactly what father's objections might have been. But again, the agreement limits it to the children's best interest. And I think that leads both parties to be able to impose their own criteria in determining what are in their children's best interest. That's something the parents have to determine. And I agree with your point, Your Honor, that it's something the parties would have had to agree on. It's not something that my client could have unilaterally decided upon. But I do think before he was required to agree to a distribution, he's allowed to consider that criteria. I would also point out, though, that I don't think that part of what was happening was really something that was resolved by the court and really under appeal here. The issue that is appealed is not that father abused his discretion on the children's best interest. Mother didn't ask for the court to resolve a disagreement between the parties as to what's in the best interest. Mother asked the court to simply strike the best interest standard from the agreement altogether and just order all college expenses to be paid. And that's clearly something that's not allowed under the agreement and would effectively be a rewrite of the agreement. Did I answer your question, Your Honor?
You did.
I think I'm about out of time. So in conclusion, I'd just like to say again, I think a plain reading of the settlement agreement, there's nothing in here that clearly requires the parties to transfer the 529 funds to their child at the age of 18. And in fact, I think such an interpretation is contrary to what the provision as a whole was designed to do, which was for the parties to manage the children's college funds as they're attending college, which would be past the age of 18. The court cannot make an agreement the parties did not make for themselves. So I think the trial court was correct in denying Mother's motion to enforce, and I would ask this court to affirm that decision. Thank you.
Thank you, Mr. Drobeck. Mr. Booth, you have 5 minutes.
Thank you, Your Honor. I don't see the parenthetical as contrary and to lapse into being grammarian. We have the IE, which is that is. And then we have two parallel opportunities there, the Uniform Gift to Minors Act, and then or reaching majority under the terms of the original conveyance. Those pair with the other two possibilities of 529 account or uniform gift. The only difference is the order is switched. So very clearly we have a termination point until such time as the funds belong to the children. And then that is under the terms of the original conveyance. And if you the purpose for a Uniform Gift to Minors Act transfer is to both have the asset transferred for the benefit of the child and to set a termination date that may differ from other law. So you can put a bank account or any other sort of asset out there, which inures to the child as soon as they're capable of ownership. When are they capable of ownership? That is a matter of the state law 38101 or some other date that you said, as Judge Hill mentioned, in the contract itself or in the conveyance itself can make that. So the baseline of when a child would receive an asset that has been given to them during the age of minority is when they're capable of contracting and making use of that asset. And that is clear under Kansas law. The whole of the agreement in the sense of this distributing these assets had to do with moving and understanding what they were doing with respective debts, assets, et cetera. It's part of a property distribution list. And it was to distribute property in one phase or another. In other words, to dispose of the property. And we clearly know there's going to be a disposition of this property. You can't have the children, this idea that the best interest of the child control goes on out after the age of majority contradicts the plain language in the first provision. The only time they really say college savings plans isn't to dedicate it to the purpose. The first paragraph dedicates the accounts to a purpose and administrates what to do with those accounts. The second paragraph is where the words college savings plan come up. And it's simply a descriptor of the 529, dealing with the idea of these tax consequences if one or the other trustees move in a way that has a tax detriment to their co-trustee.
Mr. Booth,
Yes.
I asked Mr. Drobick a question. When, if it's not the age of majority, as you argue, when does this, under its own terms, this agreement end? When do these funds ever get turned over to this person?
The
And he
language,
said,
Yeah.
Go ahead. What's your response to that?
there is
I heard his response. Now I'd like to hear yours.
there is only one termination date, and that is reaching of the age of majority. There weren't other choices offered to the trustees. They are to administrate an account until it ends, and then that is under the reaching majority. It's the plain language. There is no other directive. The holding on in perpetuity is an unreasonable result. The trial court wrongly insinuated that the owner of the account, as though the record owner of the account on the 529 account, could do other things with the money, including transfer to other siblings or grandchildren, etc. That's not true. This money was dedicated to the subject child under the terms of the original conveyance, plus this transfer of that account into a trusteeship, and that clearly they were going to wind up at some juncture having individual ownership. I think both parties now agree to that there has to be an event and a time in which this subject child, and in this sense, child meaning progeny, winds up with full ownership. So they get two benefits from this trust. The first benefit is obviously the funds that have been dedicated for their use. And the second benefit is the fact that they will wind up with ownership of that money. That answer your question?
Yeah, thank you.
Sorry, if I can interrupt just a moment. I needed clarification on a point from your opening argument. If we agree with you that this carries over at the age of majority being 18, was your point that then Alex would absorb any tax implications for an impermissible spending from that account or an impermissible withdrawal from that account?
Yes, and we outlined the law on that point fairly clearly. 26 USC 529 is what makes 529 accounts. Gee, doesn't that make it surprising? And it leaves to state law when the transfer of to allow transfer of ownership. KSA 75646 allows for the transfer of one owner's account of a college savings to another owner, much like I said originally, like a quadro, in the sense that you would move that money from Emmanuel's account to Alex's account, and then Alex is the one responsible for distributing to the beneficiary, and he could make himself the beneficiary, and also responsible for any possible tax consequences that would arise out of the misuse of that account. All the other tax consequences have already been resolved in the sense that transfers to these accounts are tax protected in the sense of how those move from one person to the other, and it would not count as a negative tax consequence for Alex, in the sense that he would not suddenly have, there's about 100,000 in the account at the start of the story, he wouldn't have 100,000 income in that year. He would just be the beneficiary of it. So, and it's very analogous to how we divide 401k plans and similar plans in divorces, in that we can transfer the tax protected entity whole cloth with all the benefit, all the basis, et cetera, over to a new owner without any damage. And that is clearly what this contract contemplated doing. Does that answer your question?
Yes, thank you.
Mr. Booth, you'll need to sum up. Your time's about up unless judges have other questions.
Any other questions? I believe I've concluded my argument. Thank you.
Okay. Thank you to both counsel. We appreciate the arguments, and we'll take the case under advisement and get you in a written decision when we can.
Mr. Drobick, thank you.